All right, everyone here on the State versus Sheila Warren.
Can you hear me, Judge?
A moment.
Can you hear them?
Can everybody hear me?
Good morning, Your Honor. We're here on Sheila Keen Warren on a status.
I can hear you, Judge. Yes, sir. Reed Scott, I'm out of the state of Florida. Good morning, Judge.
So to make sure all the players are here. So we got me, we got Mr. Lubin. See,
Got Miss Morse, and I think Greg Rosenfeld is about to be on.
I told him earlier this morning.
Right, I heard you're in trial from that. You're right.
By the way, we have a jury out right now, so depending on what happens, I may lose you guys. So we'll see.
Can we give him 30 seconds to get on, Greg, and then if not, we'll just proceed.
We're not expecting anyone to come to the courtroom, right? This is all
Right.
Okay, good.
Right.
And this, so the defendant's presence is waived, right? We agree to that. You all agree to that?
Yes, Judge.
Correct?
Yes,
Yes.
correct.
All right, we'll give Mr.
Rosenfeld. Yeah.
Judge, I believe Mr. Rosenfeld is in the waiting room.
There he is. There he is. He's on now. Okay. So we're ready to proceed if the court is and Mr. Scott is.
Yeah, so we're here on State versus Sheila Keen Warren on the case number 2017 CF 8722. For the folks that are hearing on behalf of Mr. Reed Scott, you're on behalf of the state, correct?
Yes, sir. Reed Scott, I'm out of the state of Florida. Good morning, Judge.
Good morning, sir. And for the defense, if everyone will state the appearances, please.
Yes, Your Honor. Greg Rosenfeld.
And Richard Lubin.
Amy Morse.
Here on, all three of us are here representing Ms. Keen Warren.
Okay, so I set this for a status basically to just talk about when the defense had filed on January 4th, a motion to set conditions of pretrial release. Subsequently, they came onto the bench in mid-January. Then I was contacted about setting this case for a hearing. I believe a letter from maybe Mr. Rosenfeld was requesting a half a day to have this matter heard. So I wanted to talk to Mr. Rosenfeld and his team and Mr. Scott about whether that's too much time or too little time, whatever. Because there was some mention that Mr. Scott may need some more time. So I wanted to get your thoughts on whether you have conferred, whether you were agreeing upon a certain amount of time, and then we could, of course, whatever I agree upon or whatever I deem is appropriate, we're going to set a date for that. So
Yes, Judge. I've had an opportunity to speak with defense counsel, and I think we're all in agreement. We'd like to request, if possible, a day and a half, and that may be too much time, but we just want to be respectful of Your Honor's time, and we don't want to undershoot it rather than overshoot it.
I hope that you guys would agree to 2 hours is definitely was not the right hope. Okay, so.
Well, that's for opening statements, Judge.
Bond hearing, that's arguing hearing, I guess, and I mean, you guys have written very lengthy. Thank you for your lengthy memorandums that you submitted, as well as significant exhibits that you've attached to the memorandum. So if we have a hearing, no matter how long we'll have a hearing, depending on how long it takes, I hate for it to be just regurgitation of what's already embodied, especially for the purposes of bond. But am I going to be hearing new stuff that's not wrapped up in the presentations that have already been submitted, both in memo form and the exhibits?
Well, Your Honor, the state does carry the burden, so I think that does depend on what Mr. Scott depends on introducing at the hearing. But realistically, we anticipate a day, but again, just to be respectful of the court's time, we'd ask for a day and a half. Now, I don't know if Mr. Scott intends on introducing other material.
Or if there are things we could agree on that he would decide he needs and wants, and that he would agree on that we want. But I think it's going to be at least a day, and I understand that may put it off a little bit longer than you had planned. But it's an old case and it's a complicated case and there's a lot to it.
I get, Mr. Lubin, that it's old. There are several, there are lots of other murder cases that are unfortunately tied up in the system because of COVID right now. People are, victims are waiting for their day in court, as well as the defendants who are lying in custody. I get that. And of course, your client is one of them. So, but the question that, I mean, I have a lot to read through here with all that's been submitted. I don't know if I'm going to get more stuff from y'all. But I certainly would have reviewed all those documents prior to court. You know, so I'd hate to have to, you all intend on simply rehashing the same stuff I would have reviewed. Again, this is not a trial, it's a bond hearing, right? So is that what the intent is, to simply, do you plan on calling witnesses?
Well, the state does plan on calling some witnesses. I do believe that a lot of the material that we would present has already been submitted to the court. But the state may call some witnesses just to elaborate on some of those points. I would be willing to submit a list of stipulations to proposed stipulations to all defense counsel. And if we can agree to stipulate to a number of pieces of evidence, that would cut down significantly on the time that I intend to present. I mean, I can never guesstimate how long defense is going to take on any point of cross-examination. My intent was to present at least what I had to present within a half a day, maybe 3 hours, but I don't know what defense is going to be doing.
So just
there are depositions that were attached, right? I can read those depots, and
yes, sir.
And those are not a controversy. This is a sworn statement of witness A. This is a sworn statement of witness B, right? And
yes,
I will have prepared and reviewed those prior to coming into the court for the hearing. So, there'll be other witnesses that will be testifying, and Mr. Scott, at that bond hearing?
There may be a few live witnesses that testify, but like, as I said, I can streamline a lot if we can come to an agreement with defense counsel that we're going to stipulate to these pieces, and I can, I don't need to call, a lot of witnesses, and your honor's correct, is that most of the material are in the pleadings that have been submitted. So,
if I could, let me just, if I could, Your Honor, we've got an issue, and the whole COVID problem has prevented us from taking some of the depositions, but there's some FBI analysts on the DNA that are in dispute. I think if the state were planning on a half a day, I think we at least
riding a motorcycle, or if you could put whoever's not talking, if you can mute yourself.
Unfortunately, the gardener has picked this time to mow my lawn. I'll ask him if he could shut up. Hold on 1 second. I learned how to say no leaf blower in Spanish now.
Bueno.
Okay.
Judge, could I? Oh,
So I'm gonna give you all a day, and then if you need more time, then we'll figure something. Okay, I think I should have enough time to.
I think
And the like, to make whatever presentations you want to make, and I'll probably give you like 3 hours aside. And
I think maybe we can make that happen with an agreement on some stipulations and so forth. So that would be generous of the court. So,
and also, in the cases that recently, I think we set for trial. I think it's September, if I'm not mistaken, right?
September the 8th.
Yeah. I don't think the trial date's reasonable, no matter what happens at this hearing, with the depositions we're going to have to take. And we even have one out of the country, as I understand it. And it's difficult, but we can worry about that at the hearing, I guess.
All right, okay, so let's, when do you guys want to do this? Mike.
Well, we'd like it as soon as reasonably possible, depending on the court schedule.
Like if I said it in a couple of weeks, would you be available if we could agree upon a day, or do you need more time than that? I'm not saying I could, I'm just asking you if, you want it said March or April?
March. I mean, the state's agreeable, maybe the end of March if possible, if that's agreeable to defense.
I mean, you want it said March or April?
March, I mean, the state's agreeable, maybe the end of March if possible, if that's agreeable to defense.
I mean, you want it said March or April?
I think so.
Yeah,
Don't
I
you?
think March is probably looking at my calendar.
Monday is, so I prefer the 30th.
How about March 30th?
I can do that.
We'll hope to get started at 9:30.
Yes, March 30th. Is that good for you, Amy and Greg and Reed?
Yes, that's perfect.
That date's good with the state, Judge.
I'm sorry?
That date is good with the state, Judge.
All right, so let me ask you guys this. Are we going to do this on Zoom? Or what's the thought? Have you guys talked about that?
It's essential. I think we'd prefer in person.
Nope.
I can do it in person, Judge. I would just need to know if the court would allow some testimony to be presented via Zoom.
And we would,
Yeah, especially when that's a bond hearing.
we would have,
Right.
Okay.
we have some concerns with that, Your Honor, and we would object. Obviously, I mean, the state already filed a motion to perpetuate testimony of one of its witnesses due to health concerns. And as Your Honor knows, this is an adversarial proceeding. So if their witnesses become unavailable, this satisfies confrontation.
I
So
will
that-
overrule that objection as well. As a matter of fact, it's a bond hearing, okay?
Yes, Your Honor.
Opportunity to examine the witness on Zoom. It's not a trial. So, more people on there. The other thing is, so we would obviously the defense would want the defendant here present for the hearing, right?
Yes, Your Honor.
That's great.
Okay, so March 30th at 9:30, we'll have a very lengthy bond hearing. Hopefully we can wrap it up in a day. And like I said, if you guys can reach stipulations well before that, I appreciate that. Send to me so I can review that, so I'm prepared as possible for the hearing.
We will get with Mr. Scott and see what we can work out.
All right.
Yes, sir.
Anything
Judge,
else?
thank you very much, Judge. We appreciate it.
Thank you, Judge.
All right. Have a nice day.
Thanks, Judge.
Bye-bye.
Thanks, Judge. Have a nice day.